Hello, everyone. My name is Geraldine Fisher, and I'm a legal counsel at ICSID. Today, we're going to talk to you about emerging best practices for virtual hearings. The arbitration community has long discussed the promise of technology, but we have only been using it for limited purposes. Since early 2020, our community has been pushed to go fully virtual. I think it is fair to say that in these last few months, we have all learned a tremendous amount about how to use technology in arbitration. Today's session will start with a video of experienced counsel and arbitrators highlighting practical tips for virtual hearings. Afterwards, Ms. Ariel Yi, a prominent arbitrator and counsel based in Shenzhen, China, and Mr. Gu, a vice president of CTAC's arbitration court, will provide their perspectives on this topic. Without further ado, let's hear from our friends and colleagues around the globe. A threshold question is to determine whether the applicable arbitration rules allow for remote hearings. For example, under the ICSID rules, remote hearings are clearly available.
I have developed, I think, a pathway, a pandemic pathway, and published on this. And my point has always been that you need to go through this test, whether the tribunal or the parties, to look into the different options available under the parties' agreement, the law, or the rules. Now, obviously, if the rules, the applicable procedure rules, are different from what the specific law of the seat provides, the tribunal need to conduct a test to see whether the specific rules dealing with technology or virtual hearings is of a mandatory nature or not. I, for one, would find it very difficult to perceive a situation where a law would mandate or a rule would mandate physical or virtual hearings as being mandatory. But again, it's part of the analysis that the tribunal needs to conduct.
If a remote hearing is going to proceed, the next step is to figure out the technological needs as well as the logistics. All hearing participants need to have certain equipment for a remote hearing. The basics include a computer with an internet connection. We also recommend an Ethernet connection because that allows for better connectivity. There are also accessories that make remote hearings easier. For example, I like my headset with the attached microphone.
From a technical point of view, what you need is, of course, professional equipment. With an iPhone in the corner of the kitchen is not a good place to have an ICSID hearing. You need professional equipment, you need at least 2 screens, you need good cameras, you need good microphones, loudspeakers, and everyone needs to have them.
We are here in my office in Brussels, where I conduct my virtual hearings. So what you see here is my screen. It's a large screen because I have one large screen because I prefer one screen over 2 or 3 screens because it gives you a quicker overview of what is going on in the case. And what is interesting of this monitor is that the software allows you to partition the screen. On the top left, you see a Word document that's open. That is notes, where I take the notes of the hearing, whether witnesses or argument. And then on the left bottom, you see there the transcript is running of the hearing. Top of the screen, you see a camera. You see a little black lid on it. That is, if you do this, then unauthorized people can't see you. There is on the left-hand side, what you see is a microphone that is as a specific request by court reports in a number of cases. They want to have better sound for court reporting. So what I did, I bought a USB microphone, which is a Word Century USB. The advantage of this one is not only the sound, but also it has a separate mute button, which is quite useful.
On my main laptop, I was running the video conferencing platform, and also alongside of that platform window, I was running a smaller window where the chat function of WhatsApp was being run to allow conversations, brief conversations within the tribunal. So that was my first laptop. My second laptop was loaded with all of the exhibits and pleadings and legal authorities so that I could pull them up very quickly if I needed to during the course of the proceeding. And then I had two iPads. One iPad ran the transcript as one would do in an in-person hearing. And then on the other iPad, I had all of the demonstratives and the witness examination bundles loaded.
So first, it is critically important to have a sophisticated IT platform that can manage virtual hearing by connecting multiple sites in multiple jurisdictions. This could be a challenge if speed and connectivity of internet access varies depending on the sites. And also, audience participants, it's better to have good headset to transmit sound clearly, and you better to have good camera and adequate light so that you can clearly see the facial expression of speakers.
How you set up your equipment is also very important. The other thing that you must remember is that everyone in the remote hearing can see you, so you have to remain cognizant of that.
A lot of people have their camera wrongly placed. In fact, a lot of people make the basic mistake of looking down at their camera because their camera is on a laptop often and it's positioned quite close to them. What you don't realize is that for the tribunal watching that, they get what is called an up nostril effect, which is seeing more than you want to see. You're not seeing the advocate properly, you're seeing them in a distorted way, and it looks very awkward. So you need to try and have your setup in such a way that you can actually look directly at the camera and imagine what that looks like to the other person who's looking at the screen.
And in general, the sound quality is much better if participants do not use room microphones or computer microphones, but rather use dedicated headphones with a microphone in the headphones. This does not mean that participants need to look like they are airport workers on the tarmac with huge headsets. I'm using today high quality noise canceling earbuds that are very comfortable, and I've been told that the audio quality is fine with these.
Tribunal and counsel will often hold at least one preparation session to make sure that there are no connectivity issues and everyone has a certain familiarity with the platform. Oftentimes, the tribunal and the parties will hold 2, 3, or even 4 of these sessions.
So the most important thing is the tribunal makes sure that the parties have full ability to present their case. Of course, some developing countries have problems, but even very developed countries in a lockdown situation, you never know. You are in a remote area or some other technical reason, the connection is not so good. When connection is not so good, then you have a big problem. So I think that the key important thing is to make sure that parties have actual ability to present their case.
And I think the proverb "practice makes perfect" sums it up. So it's basically holding a lot of test runs to make sure the voice quality is good, the picture quality is good, the internet connection works.
And of course, obviously, if all participants are able to make it to the test run, it's helpful because then you get to test the platform in reality, whether it is sustainable and stable when everyone logs in. That includes, of course, court reporters, interpreters, the witnesses, the parties, the counsel, the arbitrators.
Management. All of this takes time and is the result of an iterative dialogue between the tribunal and the parties. And questions will be asked, things need to be tested. And it's important for the tribunal to focus, I think, on the weakest link, which witnesses or which set of counsel have the least bandwidth, have the least access to equipment.
These types of issues are dealt with at the pre-hearing organizational meeting. During the pre-hearing organizational meeting, the tribunal and the parties should also work on and finalize a hearing protocol.
It is extremely important that tribunals aiming to efficiently and properly manage the proceedings to have a protocol for the remote or virtual hearing. It could be hinted in PO number 1 initially, but definitely it may require further detailed insight and regulation in a pre-hearing order that regulates the conduct of the remote hearing. And part of the procedural issues would not just be the technology, but also what we call the netiquette, or what the parties and counsel are expected to do in terms of conducting the hearing, when to speak, when to stop, how to raise a hand, address all these matters.
Two of the most important issues to work out are dealing with time differences and also establishing the hearing schedule.
This is particularly acute for Asian parties because when there are parties all over the world, the Asian parties end up having the hearings in the evenings because it will be early morning in the Americas, middle of the day in Europe, and it'll be at night in Asia. But I think tribunals need to just be aware of the strain that that the time differences can put on parties in different ways. So if one party's fresh in the morning and another party's facing a nighttime hearing for the 5th day in a row, that can be somewhat unfair. And I think tribunals need to be sensitive to that.
So I had a hearing, started from 10:30 p.m. and finished 6 a.m. for 5 days. Then I'm still recovering from such a fatigue. It is more, I'll say, it's a very difficult, in a sense, it's more difficult than I personally in DC. I travel to DC and stay in DC and coming back. So we have to think about what is the best way to accommodate. I would suggest that witness should have priority. The witness of they just have to testify. The integrity of witness is the most important thing. So I think the witness goes first, followed by the counsel, because counsel should have an ability to present their case. So counsel's time zone is maybe second important thing. And then we can consider counsel's, tribunal's time zone.
Time zones. No matter how creative participants may be about sitting times, whether you start early in the morning or you go late at night, or you take longer breaks or shorter breaks, or you add days, you're still going to be dealing with some participants dialing in very early in the morning, some participants dialing in very late at night, and that can be a burden on those participants. So that has to be borne in mind by the tribunal. I think accommodations have to be made for rest, for shorter hearing times. And it's important to ensure that the burdens of the awkward time zones are distributed on both parties to the extent you can. You don't have one party always testifying at an ideal time of day and the other side always testifying in the middle of the night. Ideally, you shift around, and that also means the tribunal itself has to be flexible.
If you all meet in the same place, it doesn't matter that one witness comes from the US, another one is from Europe, and the tribunal sits in Asia. Now, if you try to do this via virtual hearing, I have one coming up next week where we basically start in the morning for witnesses from Asia, and then we break over the afternoon, and then we resume at 9 p.m. until midnight for witnesses from the US. And that I assume that's going to be quite exhausting. So it's on the one hand, it's good, we can do it, and we don't have to wait for a better future where we can all meet in person again. It's definitely exhausting, and it's definitely difficult to get everybody under the same virtual roof now.
It's useful to invite parties to set time limits in the planning of the hearings, so that there are times that the tribunal understands that a party should not be made to sit beyond, or perhaps a time that a party should not be expected to attend before that moment.
The first question is, can you extend the length of the hearing as needed to make sure that the parties are afforded sufficient time? That will, of course, depend, as it does in every case, on how many witnesses are to be heard, what's to be accomplished. Maybe you won't have to add days. But in the 2 remote hearings that I've now had successfully, one was originally a 2-week hearing, and we ended up extending it to a 3rd week to ensure that the parties would have sufficient time with shorter hearing days. The other was supposed to be a 5 hearing day hearing, and we added 2 weekend days to bring it to 7 hearing days, precisely to accommodate the disparate time zones and the need to have shorter days.
Despite all the preparation, one also has to understand that technical glitches may come up, and you have to remain flexible.
Try before, not once, at least twice, and try with your main equipment, but you must also have a backup, because things go wrong, and they will definitely sometimes go wrong. You need a backup. You need a backup system of communication, of getting back into the hearing, and you should also have tested the backup. You don't want to test it for the first time in a moment of crisis during the hearing.
The technology we are using, the all different type of the application, is good enough, actually even better than in-person hearing. But at the same time, I never had any hearing without any technical problem. So always technical problem happens. So we must prepare the situation.
We have not yet peaked in terms of the technology suited for arbitration hearings. People are making quantum leaps, and technology is being developed on a daily basis. And services to support online hearings and virtual hearings is proliferating in a way. But still, there are hiccups in terms of technology, especially when you stay online for a long period of time.
It can very much help if you are using an experienced technology provider, whether it's an outside provider or an institution that has in-house people who may be able to work privately with the witness in advance of the hearing, just to make sure that everything has been set up right, to test it, to give the witness comfort. You don't want to leave anything to chance for the hearing itself.
I think the key is to be patient, to have everybody work together, to find a problem and fix it, and to actually leave a bit of time for these issues in the daily schedule.
Parties also need to feel confident about the security of the platform.
It has to do with who can connect physically to the remote hearing room. And depending on the platform you use, there are a variety of mechanisms, but you might call them waiting rooms. Somebody, whether it's the institution or a remote administrator that's been hired for the case, should collect all those who dial in a waiting room, if you will, and then make sure that they are properly identified, that you don't just have abstract names or phone numbers assigned, and then only let them into the hearing room once everyone's ready and everyone has been properly identified. That prevents someone from just dialing in midway through the hearing.
If your dispute is under a treaty that requires full transparency and open hearings, another issue that may come up is that your remote hearing may have to be available to the public at large.
The challenge really is when it comes to confidential information. So when there's a discussion about confidential information. And in that case, you have to take certain precautions. Of course, that's not unlike the current situation. In an in-person hearing, you also have to account for that. In the case of remote hearings, the secretary of the tribunal won't have an easy way to scan the room to see, for example, if somebody's raising a red flag to say, oh, should be closed, the session should be closed. So it's important that you put in place a protocol so that there's one person in charge of communicating, perhaps with the secretary, to indicate when a portion of the hearing should be closed, or if the speaker itself can flag it for the tribunal.
Tribunal and counsel should also address how they will communicate during the hearing off the record. For counsel, this means what is going to replace the sticky note your colleague sends to you during the hearing?
I think the most important thing, of course, is to set up a channel of communication using some sort of a chat function, whether it's a chat function that is used internally within a counsel team already, or set one up specifically for the hearing. But there are obviously a number of chat programs you can use, from WhatsApp to other services. But obviously it's important to make sure that everybody on the team can access it, whether it's counsel, whether it's the client, co-counsel, and that you have set up preferably different channels for communicating to the client, communicating with colleagues, communicating with co-counsel. And one thing that we have not done, but having had the experience now with several hearings, I would recommend to do is actually to also set up a chat channel with opposing counsel, because that way you can potentially resolve some issues that come up during the hearing faster without having to bother the tribunal or to interrupt the hearing even.
As counsel in particular, for remote hearings, there's a great feeling of isolation. You don't have people sitting with you. You may have one or two, often you'll have nobody. You won't have the full complement of lawyers working with you, and you won't have your client with you. And that means that making quick decisions, answering questions promptly, being reminded of documents is very, very difficult. That's difficult in the course of submissions, in particular when you're getting questioned by the tribunal. It's massively difficult during witness examination, where a witness may say something and your team wants to remind you, or somebody's got an idea of where there's a reference that may be helpful in another follow-up question, but they're not in the room with you. So what you really need to do, and what I now do regularly, I think it's common practice, is you have to have a dedicated screen with you, which is actually within your field of vision, and some communication system, such as WhatsApp or some other platform, where your team can send you messages and you can respond. And what I've done now is I've been quite frank with tribunals and with judges in court when I need to take instructions in a way that I wouldn't if I was just in person. In person, you subtly will have somebody whispering to you, or you'll receive a note. I think in remote hearings, everybody appreciates this huge difficulty. So very frequently, I will say, I need to stop for a few minutes in order to take instructions and catch up with the messages that may have arrived at that point.
The tribunal faces similar issues when they would like to confer during a hearing. To address this, they often set up a separate mode of communication, such as a WhatsApp group, so they can discuss issues amongst themselves during the hearing.
Such apps can, of course, be set up on a phone, but a tip that I got from a tribunal secretary, which I found very helpful, is that those apps can also be loaded onto the main computer screen, and then that can run just alongside the main screen where the video conferencing is shown. That's helpful because then if a tribunal member needs to send a short message to another tribunal member, one can type on the computer directly as opposed to hunting and pecking on the phone in the middle of the hearing.
One may also want to think about who is actually seen on the screen during the remote hearing. This is an issue that is also addressed in the hearing protocol. Generally, only the key participants will be seen on the screen.
Let's keep the number as small as possible, so that tribunal, lead counsel to each of the parties, and then the witness or the expert who is deposing. The others should be on video off and on mute, and so that everyone can focus and can have in a big size on his screen the images of those who are really relevant. I think that that is the better solution than having 50 small screens and then suddenly someone is speaking from the second screen and you don't know where it comes from. And this also limits the number of persons who actually speak. It happens in a hearing room, and it should also happen in a virtual hearing room, that those who speak are really lead counsel, the experts, the witnesses, the tribunal. If you want the secretary at some stage, if there is a point, procedural point where you want to approach the secretary, but not everyone else.
Another question is how to handle presentations and the display of key documents such as exhibits during a remote session. Counsel often uses the share screen function to display both their PowerPoint and key documents.
First, I have one advice for counsel, and that is if one counsel is speaking or examining, he or she should never be at the same time the person responsible for the documents, because it distracts. You have to start looking for the document, trying to get it up. It does not get up, and you are distracted from your presentation or examination. It should always be a second colleague.
And so what becomes essential is to have a very, very easy electronic bundle where anybody can navigate. And the key to that is as many bookmarks as possible. That means that if you've got a large bundle or a series of bundles, you've got bookmarks in the PDF where anybody can just click on them like tabs. And actually, once you get the hang of that, it's much, much quicker and much easier than a physical bundle. I've done one witness hearing, which was a disaster because the bookmarks and the pagination was not quite the same that everybody had. And so it's absolutely imperative that everybody's got exactly the same electronic bundle with the same bookmarking, same pagination.
Then in terms of showing the witness the document, I've seen this managed in two different ways. One was a case where we had a document management consultant retained to assist in the case, and that provider would pull up on the witness's screen the particular document that the witness would be examined about. In this case, the witnesses were all sent remote packages of equipment, which included several monitors, for example, and the packages were controlled remotely by the provider. So the witness had no stored documents on the screen, no ability to receive emails or coaching, no ability to quickly look at other documents. The witness was shown only what the provider pulled up for the witness. So that's one approach. Another approach I've seen work in another case is to have the traditional cross-examination bundles or binders prepared by the examining counsel, sent to the witness in advance, for example, in a Federal Express box, but not opened by the witness. And then at the beginning of the examination on camera, the witness opens up the box, pulls out his or her binder, and then is asked to turn in the customary way to tab 3 or tab 5 and so forth. That worked very well in a case I had where the parties were all more or less in the same country, so it was easy to send cross-examination binders by Federal Express 2 days before the hearing. It would not work well in a hearing where witnesses are all around the world and you're dependent on courier delivery to get to different continents in time.
If you have a very large sum of money at stake and the costs of the hearing don't matter so much, the probably easiest thing is to have a document vendor that takes care of that basically hosts everything in a cloud and might even have people that then bring up the documents when they're spoken about. I think that is definitely the easiest way for the tribunal and the parties. But of course, it's also expensive. So if you have smaller arbitrations, you can find ways to kind of replicate that. So what we've done is we've basically created an e-bundle, and then there's then again two ways how to work with that. One is to share documents through your video conferencing application. So basically, you share the screen. Or what we did a bit of a hybrid. We had a screen sharing, but the parties, the tribunal members, and the witnesses had the documents basically on a second screen, which was quite helpful. If you need to read like fine print or small drawings, you can actually blow them up, which is difficult to do when you share the screen. So basically, we used screen sharing to kind of know where we are with the document, but everybody had a second screen to be able to kind of zoom in as they wanted and to look at the documents. And that actually worked quite well.
There are often certain aspects of witness examination that are specific to remote hearings. First of all, you have to think about the perspective of the witness.
I think logistics, first of all, is very important. Witnesses can be very, very uncomfortable when they testify. The problem with remote hearings is differences in time zone. So you want to be sure, first of all, that you're not asking your witness to testify at an unreasonable hour or an awkward time, because that just makes the whole situation even more tense. So there has to be some compromise with time zones. There has to be also some sort of leveling in terms of technology, because there are differences in the availability and reliability of the remote technology. So you've got to have your witness in a place where the time zone is kind to them, and secondly, where the technology is tried and tested, so that in the course of the exercise, if there are interruptions, the witness is not blown off course and made to feel even more uncomfortable, or the exercise becomes even less accessible to everyone because of those difficulties. So that requires a lot of, even more than you would think, technology testing and dry runs beforehand to make sure that everything is compatible and works. The reality is that it is difficult to cross-examine or examine witnesses and experts remotely. And so what that means is you must reduce the scope of your planned examination. You cannot do really nowadays the same cross-examination, direct examination that you would do in person because of difficulties with duration, attention span, all the other logistical difficulties. So what I've seen is actually cross-examinations in particular have become much more focused. Which is no bad thing.
The specific question is how to ensure the independence of witnesses. Parties will confirm that the entire room where the witness is located is visible, and they will also ask that the desk be visible. Some will also require the use of a 360-degree camera.
There are particular challenges that arise in respect of witnesses, and I suppose they're broadly of two kinds. The first is precisely how the witness is to be examined and cross-examined. And here there are a cluster of issues, but among them it's important to ensure that the materials that the witness has access to and the way in which the witness is sequestered for the purpose of giving the testimony is well worked out in advance. Because there is a risk that there could be either some coaching or guidance or access to materials in a way that is not as disciplined as would occur if there were a live hearing. So that's the first cluster of issues that I think needs to be dealt with.
For that, of course, you need to have agreements and protocols worked out. Who is permitted to attend, for example, with a witness who can sit in? How will that be verified, or is there a trust system? If you need to verify it, one system that has worked very well in one of the cases I did was to have 360-degree cameras distributed to the witnesses and experts, which would allow the tribunal as well as the parties to scan the entire room and make sure that there's nobody attending who has not previously been authorized.
More generally, there are some challenges to remote examination of witnesses. We see here again that preparation is key.
The second point to be prepared is for the parties and counsel and tribunal to agree to due process protocol. For example, the manner of witness examination, whether witness is permitted to participate in the hearing together with counsel or other party representatives, or how and whether the communications between counsel and witnesses are permitted during the hearing, whether a neutral person is better to be present at the venue where the witnesses are cross-examined. This manner of witness examination is critical in the remote settings because unlike physical setting, party or counsel which is examining the witnesses do not necessarily see what witnesses who are cross-examined is doing.
The other thing that's difficult about presentations is interventions. Because of the technology and sometimes the lag that we experience in the computers, interventions are less smooth. And what I've experienced so far is that tribunals end up interrupting counsel with questions much less. And they tend to save the questions for the end of the presentation, which of course is perfectly fine as long as one is prepared for that difference between an in-person hearing and a remote hearing.
Despite these considerations, many feel that witness testimony during a remote hearing has many advantages.
I think doing a hearing with a remote camera allows everybody in the room the identical view of the witness's face, generally zoomed up so you can see facial expressions well and often better. In a hearing room, the tribunal may be 6 or 8 feet away from the witness. The examining counsel will be on the sides of the room, perhaps seeing the witness full front when the witness turns to look at counsel, perhaps only seeing the side of the face. Party representatives, junior counsel will be further down the table, only seeing the back of the witness's head. And so different people in the room will have different perspectives about what facial expressions were made, whether the witness seemed nervous or not.
But the benefit of that virtual hearing is that we can replay video. Extremely helpful. You just take a video clip, and even our submission, we just have a linked the video clip so the tribunal can see that. So and also tribunal can always go back to a particular point and hear what witness said.
The curious thing about remote hearings when you are an arbitrator is that whilst you might not see all the body language of witnesses that you would see in a physical hearing, you actually get a close-up of somebody's face while they're testifying in a way that you never would do previously, especially for those of us who don't have brilliant eyesight. It's quite an interesting experience when you see somebody very close up on the screen testifying under cross-examination, and what you can pick up from facial expressions, from movements, from just a visibility that actually is completely new.
Interpretation can also be handled very capably in the context of a remote hearing. Oftentimes, simultaneous interpretation is used. Sometimes, however, counsel may want to consider whether consecutive interpretation may be better for a particular witness or a particular language.
And there are two schools. There is the simultaneous interpretation and there is the sequential or consecutive interpretation. What I have seen from remote hearings I've been involved in is that there is more into the sequential interpretation. So the witness speaks and then the interpreter speaks. But I have seen in reality that simultaneous interpretation on certain platforms is a possibility. It's exactly like turning channels, having virtual rooms for the interpreters to interpret that. So I think the services on the simultaneous interpretation side will more and more creepingly find its way into the practice of arbitration in remote hearings. One thing that I predict will happen in the very short future is that we will have machine interpretation simultaneously, multilingual on different channels, and it's just got to be as accurate as expected. But I think we're moving into that direction.
With respect to advocacy, counsel must adapt to the virtual medium.
So I think one of the principal considerations when thinking about remote advocacy as opposed to advocacy in person is that it is completely different. You cannot approach remote hearings in the same way as an advocate as you would approach an in-person hearing. Speaking to a camera and being listened to on a screen are totally different experiences. And I think in many ways, that means that we as advocates have to relearn our principal craft. It's difficult in terms of a lack of eye contact. It is difficult in terms of a lack of presence and actual physical proximity, which means you cannot read the tribunal in the same way as you would if you were in the same room. You can't sense how they're reacting, whether or not your advocacy is having any impact, whether it's liked, whether it's not liked, whether it's irritating. You can't read your opponent as you're speaking. You can't see body language in the same way. And overall, you're dealing with a limitation on attention span because you can't actually grip somebody in the same way as you would do if you're there in person speaking to them directly. So that means as an advocate, you've really got to retune and be much, much shorter and try and make an impact in a different way, which is, I think, to focus on really your key points in a way much, much more than you would if you had the luxury of being in person and you could build up and you could read the situation.
One very practical tip that is extremely effective is to look at the camera to ensure eye contact.
And even though it's a tiny nuance, but if you don't look into the camera, people get the feeling like you're not really talking to them. And I think, so one of the things to connect with the tribunal and the arbitrators is to remind yourself that it's only when you really look into the camera that people feel like you look at them.
It is important to tailor your presentation to a virtual hearing. Well, first thing you would learn, and what I'm learning is, you have to look at camera. You no longer look at the eyes of audience, tribunal members, or witnesses who are cross-examining. This is a huge challenge.
Many counsel who we have spoken to have all highlighted the same thing. They say that it is important to use your time wisely, and you should focus only on the most important arguments.
Thirdly, what's very important is to recalibrate your presentation as between oral advocacy and written advocacy, because now there's much more emphasis on written advocacy because of the limitations of the technology and the limitation of attention spans. So I think having written outlines, written skeletal arguments, more detailed submissions that you can make reference to is actually not only a comfort, it's actually now a necessity.
So just to summarize, we are all still adapting to remote hearings, but we know that they offer many, many benefits, especially if we use them well.
On behalf of myself, and I believe that the audience, we really appreciate the efforts that ICSID made into bring us this video, because this video gave us a lot of tips, which is usually we don't find in the articles, in commentaries. I believe that before this pandemic, I'm one of the many that are afraid of the new technology. I believe that before that, I never attend any webinar. I'm always have the fear that something will go wrong and I don't know which button to press. And because of the pandemic, we're not offered any opportunity. We don't have any choice. We have to learn the new skills and learn it quickly. And I believe that the video gave us a new product, which is before that we see many articles, comments, protocols, and video is another innovative way for the experts to quickly share their, I call it a freshly baked experience. And in terms of what we have seen, that it's very comprehensive. I believe that the experts you interviewed gave us a very comprehensive coverage from how to use the devices, how to look at the cameras, how to use a separate channel to discuss among the tribunal members, even discussing with the opponent counsel, and how to handle the bundles, how to handle the witness. One thing I would like to share with you that our Chinese domestic arbitration hearing is quite different from international commercial arbitration I have experienced. Usually for our domestic arbitration, the hearing is relatively shorter, usually 1 day. It's not uncommon to have more than one hearing. Sometimes certain cases along the process may have several hearings. But for our Chinese audience, international commercial arbitration, it's usually you got one hearing. If the proceedings being bifurcated into two, maximum you will have 2 hearings. So therefore, preparing the hearing is vitally important because you don't get a lot of a chance. From the videos, I believe that the 3 things which is particularly beneficial to me. The first thing is make sure you have the online access. On a daily basis, everybody has Wi-Fi. It seems to be people taking for granted. It seems to be easy. But 2 weeks ago, I attended a conference. One of the speakers mentioned that his experience that for 1 day hearing out of Beijing and Hong Kong, the hearing was cut off for 30 times, which frustrated everybody. So even if in a daily time, it seems to be the lines okay, but for particularly when preparing international commercial hearing, it's important that we find out, we have a backup plan as one of the speakers mentioned. The second thing I found is very interesting about using the devices. Maybe 2 or 3 years ago, I recall that we had a debate about using e-bundles. Most of the senior arbitrators, they're so used to physical bundle hard copies, and therefore changing to e-bundles always make people nervous. I recall one of the arbitrators mentioned that she tried to use e-bundle, and then one counsel questioned saying, are you looking at the bundle? Are you typing your emails? When she looked at his own computer screen. But nowadays, because of the pandemic, I believe things change quickly. People are now get used to embracing the new technology. And therefore, the tips of having 2 screens, have 2 iPads, have an iPad, have an iPhone to set up different channels will help people to quickly switch from using hard copy bundles to e-bundles. And also the comments regarding the pagination, regarding the bookmark is also very useful because this is something, maybe Chinese users are not so familiar with. But when we come to international arbitration, it's certainly very important. The third thing I found very useful is to practice. When you do the physical hearing, it's never happened that you have the whole team, tribunal member, the team of the both sides to do a rehearsal. It never happened. It's once on the day you go to the hearing room, you start the hearing. But for online hearing, we're now advised to do the rehearsal, not just once, maybe a couple of times, not just the 2 minutes, 3 minutes, but make sure. You see, I haven't done this rehearsal. Now my fish tank appear on the screen, which I didn't expect. because earlier I was using a smaller screen. I didn't, realize that it happens. It's kind of weird. So those tips are very useful. I believe that we're going to learning during the course. One thing I want to share quickly with the non-Chinese audience about the legal position of Chinese court taking. Earlier, we heard that Justice Yang talking about 600,000 of cases which they have online hearing. And we listen to Mr. Wang Chengjie talk about more than 165 cases. They also have online hearing. But the legal position under the Chinese law is that to conduct online hearing, consent from both parties are required. If one party refuses to attend online hearing, the court has to postpone it. And this is because, with a good reason, because the Chinese court not just handle commercial disputes, they also handle criminal matters, family matters, administrative proceedings. Most of those cases may not be appropriate for online hearing at this stage. So that's how court has this position. And when come to the arbitration, because currently our arbitration law hasn't been amended to address the online hearing. So that's how currently people are talking about amending the arbitration law. People are talking about amending the arbitration rules in order to pave the way to remove the uncertainty. But for our non-Chinese audience, it is still important to understand the legal position on that front. Lastly, I believe that after hearing all the speakers today, I believe that parties will have all the confidence on attending online hearings. I believe that I agree with Mr. Wang Chengjie that now we have the online and offline combination. For example, one hearing I attend is one of the tribunal members dying from a remote place, but the parties are actually in the hearing room of the arbitration institution. So this kind of combination will become more and more common, provide the convenience and cost saving for the parties. Of course, this may also raise new issues on whether, whether one of the parties appointed as arbitrators not in the room, but the arbitrators appointed by another party in the room, whether that causes any due process issues. So we're going to see how things developed, but I believe that everybody agree that we're entering into the digital age. We're going to embrace the opportunity and the challenges. Thank you.
Thank you, Ms. Fisher, and thanks for the practical and useful ideas provided by video and wonderful comments of Ms. Ye Lu. Affected by the COVID-19 pandemic, this year's China Arbitration Summit is conducted online and offline simultaneously, which is a first try for CTAC in this special time. So first of all, I would like to express my gratitude to everyone's support and participation. During the pandemic, there is no doubt that the arbitration procedures have been delayed seriously, especially the date of the oral hearing. It's very hard to determine, which has caused much complaints from parties. Hence, more and more arbitration institutions are beginning to use virtual hearing to replace the traditional physical hearing. Regarding the virtual hearing, the video just played is truly comprehensive, covering almost all the hot issues that recently have been discussed in the dispute resolution community. Experienced arbitrators and counsels also provided us with practical advice and experience. I noticed that the video firstly brought up the threshold question that whether a remote hearing is permitted by relevant rules. I completely agree with the view illustrated that the tribunals and parties should look into the arbitration agreement, the applicable law, and the arbitration rules to find answer. However, virtual hearing is not clearly available in every arbitration rules or applicable law as that in ICSID arbitration rules. In fact, in most of the cases, the applied arbitration rules and applicable laws are silent on this issue. And the decision on virtual hearing is made under discretion of the arbitral tribunal. It is obvious that the virtual hearing is playing and will continue to play a significant role in the field of arbitration. I believe that an important work to do next is to reform the legislations and make clear the availability of virtual hearing in arbitration. The video also discussed the problems and concerns that may be encountered in each section of a virtual hearing. I believe that CTAC's practice in developing online arbitration service can be used for reference and discussion to a certain extent. CTAC has designed and launched its own online oral hearing platform in tackling the challenges posed by the pandemic. Together with the existing online case filing system launched last year, it can meet the needs of the parties to file new cases and participate in the oral hearing remotely during the pandemic. According to data, the online arbitration services efficiently promote CTAC arbitration in this special time and greatly alleviate the delay of procedures caused by the pandemic. Mr. Wang Zhengjie has introduced statistics I will not repeat. Speaking of the CTAC's online oral hearing platform itself, it is an exclusive system that specifically tailored for arbitration procedures. To elaborate further, the platform is unique with plenty of traits. Firstly, it is not a public system and cannot be accessed without the keywords provided by CTAC. Besides, the platform connects with the database of relevant authority so that before each online oral hearing, the identity of Chinese participants will be confirmed and verified by the platform. The security and the confidentiality of the arbitration proceedings can be guaranteed for use. For sure, how to verify the identity of the foreign participants is the next difficult problem to be solved. It is also equipped with the technology to convert spoken word to text so that the transcript of the oral hearing can be produced simultaneously. Of course, at that time, and now we can only provide Chinese version transcript. More importantly, the platform can achieve the effect of physical hearing to a great extent. It supports the function of uploading, downloading, and simultaneous electronic display of evidence at any time by any party. Checking and sending the hearing transcript can also be realized through the platform. Under the control of the tribunal or the case manager, the participants in the same hearing in the same hearing room can be isolated from the hearing so that the back-to-back mediation can be realized easily as well. Actually, some disputes have been settled by mediation through the platform. What also deserves expecting is that the English version of the platform will be launched soon. I believe it will be more convenient for foreign parties to participate in CTAC arbitration procedures. The last thing I want to say is I noticed an interesting phenomenon. Although the physical hearing is resumed in CTAC arbitration at present, but some parties and tribunals still prefer to conduct virtual hearing. I see it as a need and a tendency to normalize the online hearings. Obviously, with the use of virtual hearing, the parties may save a lot of costs. For example, parties do not need to travel from city to city, even from country to country to attend an oral hearing. Instead of renting a hearing room, they can attend a remote hearing at home or anywhere. as well as the arbitrator's fees on travel and accommodations. In terms of time costs, virtual hearing is much more convenient and flexible to all participants, especially to bid arbitrators and foreign arbitrators. As a result, even after the pandemic, remote hearing will still be attractive to parties and tribunals. So I quite agree with Ms. Ye's judgment. Remote technology not only has practical meaning at this special period, but is meaningful to the reform of oral hearing in arbitration as well. CTAC will continue to perfect its platform to satisfy the needs of the participants. Also, CTAC will keep developing new technologies that can simplify the arbitration procedures. I believe that it is the mission of arbitration institution to keep the pace of technology innovation and bring the convenience to the parties and tribunals. So these are my comments. Thank you.